Appeals, Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in North Star Brokerage Advisory Services, LLC versus Reed P. Collingwood. Our case number CV14-0106. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time for rebuttal if you wish to do so, sir. I'd encourage you to keep track of your own time. We will not be doing that. And there's a clock at the podium to allow you to do that. Out of respect for counsel, I know some of you have heard this before, but I would ask folks to make sure that your phones are off so our presentation is not interrupted. We have reviewed the briefs. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present oral argument today. Our proceedings are being recorded, so as you approach the podium, please tell us your name and the party that you represent, and they will ultimately be posted on YouTube in due course. With that, let us start with counsel for appellant, Mr. Klopp.
Good morning, Your Honors. Matthew Klopp of Wong & Carter on behalf of the appellant North Star. In light of the fact that you have read the briefs thoroughly, conferenced the case, discussed these issues, I, of course, have a presentation to give an overview of our positions. But if you have specific questions about our position, I'd rather go to that versus rehash what's in the briefing. So if there's anything in particular any of you are concerned with.
Well, counsel, I know one thing that would help me is if you could summarize, at least hopefully, what are, I don't even want to put a number on them, but what are the remaining claims that you're asking us to evaluate for summary judgment purposes right now on appeal? I mean, if you could just list them off. Yeah.
Breach of contract. I think that was count one, if memory serves, and that is breach of, I believe that count specifically addresses breach of the AFMO addendum. There is a count for unjust enrichment, which obviously is not dependent on any contract. There is a count for breach of an implied contractual indemnity right that can arise out of any of the contracts at issue here. There is a claim for equitable indemnity, which arises where there's no contract. And finally, there's a claim for contribution, because both parties here are the co-indemnitors of the same obligation, ultimately.
Thank you. Does the contribution claim, does it depend on the existence of a written contract? I know there's been discussion in the briefing back and forth about an oral contract versus written, but let's assume, I think I'm safe in saying this, that for right now, let's assume that the addendum was signed for all intents and purposes. I mean, let's just assume that it was signed. What do the breach of contract and the contribution claims, are they related to, or are they tied to the addendum?
If we're assuming the addendum was signed, then yes. But even without the addendum, the contribution claim survives, because under the agent agreement that Collingwood admits he executed, there is an obligation to indemnify and reimburse with respect to any chargebacks for his agents. He has admitted in his answering brief, as well as the summary judgment briefing below, that Ayala was an agent under him in the hierarchy. So he had an obligation to indemnify and reimburse for any chargebacks associated with Ayala. At the same time, Ayala falls under North Star's hierarchy. We have the same obligation because regardless of whether you're the agent, the AFMO, or the FMO, anywhere in this food chain, you're bound by the agent agreement. There are additional layers of obligations if you are upstream from the agent. But at the base level, everybody is obligated under that. And if Ayala is an agent under us as the FMO, and then setting aside whether the AFMO addendum is even signed, the concession that Ayala is an agent under Collingwood, Collingwood has to indemnify that reimbursement, as do we. And then the case, can't remember the name, but it's cited toward the end of our opening and reply brief. When you have co-indemnitors of the same obligation, there's a right of contribution, because otherwise there's an incentive for one indemnitor to just sit back, avoid paying anything, and just hope that the other indemnitor picks up the tab and then they can't come after you for reimbursement. I think logic and just a sense of fairness would suggest that that cannot be the case.
Go ahead.
Oh, any other, did I answer your question?
Yes. Well, which of these are the strongest claims on appeal in order to resolve? I mean, you know,
I obviously we believe there are.
understand your argument that there's a hierarchy, but for me, I mean, it would be helpful if you'd pinpoint exactly.
Which error is the most egregious?
Well, yeah, exactly.
Well, I think, first blush at least, I was not trial counsel. I think my name was on the pleadings, but I didn't really work on this. So when I looked at it on appeal, the first thing that jumped out to me was, how are you resolving an issue of whether there was this AFMO addendum that governs anything here when there's a dispute as to whether that was signed? It seemed that there was clearly, at the very least, factual issues on whether that agreement was signed. I think the statute of limitations, the accrual date that the trial court picked, this May 2006 date, the date when Allianz said, hey, there's going to be chargebacks associated with Ayala that are going to start being rolled up. The trial court picked that as the first date, for my client's claims to begin to run. My client has no claim until my client has suffered a loss under any of these theories. Under the INA insurance case, there are two types of indemnification, for liability or for loss. We first look at the agreements at issue to see what.
At what point could your client bring a suit?
The first time that Allianz withheld commissions that were due to my client. My client has a revolving commissions account. In July of 2008, I believe it's July 9, 2008, based on the records that were produced by Allianz in this case, or that we obtained from Allianz in this case. That's the first time my client is charged back anything related to Ayala. That's the first time my client could have sued. The first chargeback was $1,500, I believe.
There was no claim that would have accrued in 2006.
I don't see how you could, because if we're under the AFMO addendum.
Wasn't there a letter written, or at least an assertion in 2006 that money was owed?
That money is owed, but my client had not suffered a loss. My client hadn't been forced to pay anything yet that my client wasn't fairly supposed to pay. This comes back to do we have indemnification for liability here or indemnification for loss? I think that's the issue the trial court was confused as to. And that makes a really big difference here, because the liability, I think, arguably comes about in that 2006 letter. Hey, we have to reimburse, customers because of Ayala. You have an obligation to reimburse us for these chargebacks associated with Ayala. But we don't have indemnification for liability here. First, we can look at the contracts at issue. None of them talk about liability. The court has read, I'm sure, countless indemnification provisions in your 10 years as judges and as counsel before that. And oftentimes they will say things like indemnified against any liability, claims, losses, damages, suits, judgments, awards, et cetera, et cetera. Here, all of the indemnification clauses, regardless of the agreement, refer to indemnification for losses and expenses. They don't mention liability. And if the contract doesn't mention liability and it only mentions loss, we have an indemnification for loss under the contract. Now, with respect to the equitable indemnity claim and the contribution claim, which is equitable as well, as a matter of law, those are indemnification and contribution with respect to actual losses, things you actually were forced to pay. So while my client may have been told back in May of 2006, we have to reimburse money, Ayala doesn't pay, you're on the hook, North Star, you're on the hook, Collingwood. That doesn't trigger any of our claims for indemnification that we may have because we haven't been forced to pay anything. Then those chargebacks, it's not a single payment. It's not that Allianz came in and we paid all at once. They forced us to pay over time, roughly $1,500 a month, I believe, for a certain number of years. In fact, the final chargeback, and Allianz didn't fully become reimbursed until after this lawsuit had been filed. So for the court to pick one date where there's no loss and apply that to all the losses, some of which weren't even suffered until after the lawsuit was filed, was an error as well. Additionally, an unjust enrichment claim, I don't think you would have, your claim doesn't accrue until you suffered some detriment. You were forced to pay something that you weren't supposed to pay.
You may continue.
Okay. So generally speaking, and I think we've already touched on it, there's two broad categories of errors, I think, at issue here. One, the contract issues. So the court just seemed to simplistically look at this and say, well, all of your claims are done because you don't have a contract with Collingwood that requires any reimbursement. One, to reach that conclusion, I think the court had to ignore the AFMO addendum. The AFMO addendum has a joint and several guarantee obligation with respect to, here, Ayala's chargebacks. Both parties signed that AFMO addendum. Arguably, obviously, there's a dispute. Trial court must have concluded that AFMO addendum was not effective, and to reach that conclusion would have to have ignored the dispute over whether it was signed by Mr. Collingwood or alternatively ratified by Mr. Collingwood, because the one thing that seems to be lost in all of this is Mr. Collingwood was paid money by Allianz with respect to things that Ayala sold. So for Mr. Collingwood to now argue that I have no obligation, why do you think Allianz was paying you money? Those things seem to go hand in hand typically. If you're going to get something, there's some risk that's going to flow back to you. In addition to the AFMO addendum, the court had to ignore the provisions in the agent agreement that there's no dispute Mr. Collingwood signed.
But, you know, I guess the one thing you're not talking about is the fact that all of these agreements, including the addendum, were between Collingwood and an alliance. I'm not even sure if I'm saying it right, alliance. But, I mean, that's who those agreements were between. Even if we assume that North Star, I guess it was Kim Coulter, signed the addendum, it was an addendum to an agreement between Collingwood and Alliance. And so, you know, you're talking about all these agreements, but you're leaving out the fact that none of these agreements included North Star.
Well, a couple of things on that, because North Star is not directly named in any of them, but North Star is certainly contemplated in a couple ways. Number one, if you look at the agent agreement, the documents included with the agent agreement, I believe the document is actually entitled Agency Compensation and Transmittal. I'm not sure exactly what this is, but it appears to have been submitted along with Mr. Collingwood's agent application to Allianz. There it identifies 3-Mark Financial, which was the original FMO, later transfers Collingwood to North Star as the FMO. So why are we identifying the FMO in the agent agreement if there isn't some intention that there's a relationship between those parties that somehow is implicated by this contract?
I think that they're implicated, and I guess I call it sloppy drafting, because it seems to me that there should have been something, or, you know, I kept looking for something that brought North Star in with, you know, an agreement between North Star and Collingwood when they started, you know, when Collingwood went from FMO to AFMO, that an agreement between them that said, okay, now Collingwood, I am the AFMO, and North Star, you're the FMO, and here are the, you know, and in accordance with the alliance agreement, you know, this is how contributions are going to be paid. But there's nothing like that.
And I agree there's not a direct contract, and I don't know why, other than that's not how the parties did that here. I don't know if that's just not Allianz's practice, and parties don't typically do that. I can't answer that. But what I can say is, if you look at the agent agreement that Mr. Collingwood signed, also my client has one of those incorporated into its relationship. Provision 4L3 grants the right to whoever the party is in that contract to recover from their agents the amounts owed under this agreement. Well, that wouldn't make any sense if there wasn't some third party who's contemplated here. Because if the contract, for instance, North Star has a contract with Allianz that says you may sue your agents, let's say Mr. Collingwood here, you may sue your agents for any amounts they owe under this agreement. Well, Mr. Collingwood's not a party to this agreement, so how would he ever owe anything under this agreement? Clearly, it's contemplating something else. And if you read through the agency agreement, it mostly is directed at commissions going up and down the ladder. So,
But these are governed by Arizona law, correct?
the contract is governed by Minnesota law.
Has it been briefed to us that way? Because Arizona has extraordinarily limited
Everybody
third-party-
has argued this under Arizona law. I noticed there's a choice of law provision. I'm not aware of any difference between any of Minnesota's laws or Arizona's
Well,
laws
and
on
I
these
don't
issues.
pretend to know Minnesota law, but Arizona law on third-party beneficiary is extremely narrow. I mean, you effectively have to be able to find that the parties intended that a third party, if not named, was literally a party to the contract. It's not sort of, could somebody claim benefit for that? And that's why, to follow up on Judge Orozco's question, I struggle some, given that North Star is not a signatory, is not a party to the.
On the agent agreement that Collingwood signed, correct. The prior FMO is identified specifically by name. There would be no reason other than there's some acknowledgement of some rights and obligations that are flowing there.
It seems
But
like you're suggesting there was an assignment from the prior FMO,
I'm not sure how they transfer their books of business in this.
but that wasn't argued. It wasn't argued as an assignment.
No, it was just the relationship that Collingwood had to Allianz, which was under an FMO, was transferred to my client as an FMO in some way. But specifically, Judge Thumma, with respect to your comment, the AFMO addendum does expressly include my client. My client signed that. The financial guarantee
Signed
provision.
it to do what? For what purpose?
Well, the AFMO addendum, which is what gave Collingwood additional commissions on top of whatever he would earn for his own sales, anything that the agents under him, here Ayala, sold, resulted in an additional commission to Mr. Collingwood that he was paid. Under the AFMO addendum, again, Allianz is concerned with if I have to refund a customer, I'm getting repaid. And so under the AFMO addendum, AFMO Collingwood is jointly and severally obligated with FMO North Star to reimburse Allianz. My client signed that agreement, that financial guarantee. There's a dispute over whether or not Collingwood signed it. That was a factual issue that was ignored. Of course, none of that's necessary for an unjust enrichment claim, and third-party beneficiary rights don't affect the contribution claim because, again, these parties had separate obligations to indemnify Allianz for the same loss related to Ayala, and co-indemnitors of the same obligation have rights of contribution among one another. And so then it's really a question of when did the claims accrue, and that's when the loss occurs. And the loss doesn't occur clearly. I don't think there was really a dispute. The loss doesn't occur until July of 2008, which is within the statute the either 3 or 4 year statute, whichever one the trial court was relying upon. If there's anything further, I'll reserve my last minute or so.
Thank you, counsel.
Thank you.
Mr. Brooks.
Good morning, Your Honors. May it please the Court. My name is David Brooks. I represent the appellees Reed and Teresa Collingwood. My message to the Court this morning is that the trial court was right. There are no disputed issues of fact, and the trial court should be affirmed. There are 4 primary reasons why that's true. As Judge Orozco's question noted, first, there's no written contract between North Star and Collingwood that gives North Star any rights to recover anything from Collingwood. The trial court so held. Second, North Star's indemnity, unjust enrichment, and contribution claims are barred by the statute of limitations. Third, on the merits of those claims, they lose as well. And we briefed that in the briefing. And fourth, on the equities, Your Honors, I don't want you to lose sight of the fact that North Star is trying to have Collingwood pay it over $246,000 when it was actually Ayala who received the bulk of that money. Collingwood should not have to pay North Star for that which he never received. I'll address these issues in order. First, on the breach of contract. As was discussed in the appellant's argument, they have asserted a breach of contract claim in the pleading. That inherently assumes that there is a contract between the parties. And what they alleged in their pleading was that Collingwood breached the AFMO addendum. But when you read their appellate briefs, and particularly their reply brief, their argument has sort of morphed into a different kind of position, suggesting that Collingwood breached their contract-based claims. I think that's inherently because of what you heard counsel admit this morning. There is no contract between the parties. When I asked Kim Coulter the question in deposition, and we've cited this in our briefing, is there a written contract that supplies any duty of Collingwood to North Star? He sat there for a second, sort of dodged the question, and said there was an oral agreement. Now, he didn't directly answer the question, but that which he didn't answer answered the question. Second, Your Honors, none of the agreements that North Star is referring to in this case actually apply as between the parties. The AFMO addendum that he refers to is the only document that has a signature of Mr. Coulter. But when you look at that document, and Judge Brown asks the question, what is he signing for? The actual reason he signs is to say, quote, the undersigned FMO hereby confirms the appointment of the Associate Field Marketing Organization listed below as one of its agents. It says nothing about I am a party. It says nothing about that this document or agreement gives me any rights or duties as between North Star and Collingwood. And when you read that document carefully, the benefits flow to Allianz. Second, they refer to the agent agreement. As noted by counsel, the original agent agreement with Collingwood was even before he had any relationship going on with North Star. But that agent agreement, and as Judge Orozco mentioned, all of the documents, if you look at the very top of the document, where all of us as lawyers, we put who the parties are, that's sort of the fundamental contracts 101 deal. They say these are agreements between insurer or company, which is a defined term referring to the life insurance company Allianz, and agent, which is also a defined term in this setting, and with respect to the agreements they're referring to with respect to Mr. Collingwood, him. None of them are agreements that provide any benefits as between North Star and Collingwood. That's what the trial court held. Now, they suggest with respect to these agreements or this hierarchical relational situation that there are material issues of fact that the trial court ignored. And they go so far in their briefing as to say that the court willfully ignored the contracts. I disagree, Your Honors. I think the trial court understood the point of what I'm saying here. There are no undisputed facts that give rise to any duties here. And I have to start first with Ayala. We mentioned in the briefing, Angel Ayala was the underlying agent who sold the annuity contracts. When he signed up with North Star, which was Dominion Brokerage at the time, he signed an agent application. That became sort of the contractual basis of his relationship with Allianz. That document, as pointed out in our briefing, has a clause that says that this application and the commission guidelines, agent agreement, and schedule of commissions become part of this contract if they're attached to this document or supplied with this document or, quote, promptly, close quote, thereafter. The only facts in this record are that Ayala never got the documents. Those are the only documents they could cite to that suggest that Allianz, as between Allianz and Ayala, would have any obligation or right to charge him back. That's the only documents they refer to that give that chargeback right. Those documents did not become part of Ayala's contract. Now we circle back to the original reason this case got started. Ayala and Allianz got sued by underlying California plaintiffs for alleged misrepresentation in the sale of annuity contracts. Those cases, it was one singular case, I should say, was first settled by Allianz and shortly thereafter was settled by Ayala, who was defended by his E&O carrier. They obtained good faith settlements under California law, which is Civil Procedure Code Section 877.6. Allianz, even though the result of that statute says Allianz can't sue other co-obligors for contribution or another right, comes to Ayala and says, you owe me money. Even though they had settled, and Ayala, through his insurance company, had paid the underlying plaintiffs whatever they agreed to pay in the settlement. Ayala said, no, I don't. Because you don't have a contractual right to seek any money from me. You don't have a tort-based right because the statute bars you from proceeding. Allianz says, okay, I can't get money from Ayala. I'll roll it up. They go to Collingwood. Say, you owe the money. Collingwood investigates. Says, nope, Ayala didn't owe you. And even though the AFMO addendum says that my agent, or Collingwood's agent, that Collingwood would have to pay Allianz for debts that my agent, quote, owes. If my agent doesn't owe Allianz anything, Collingwood doesn't owe Allianz anything. So Collingwood said no. Then it goes up to North Star. Now, North Star was in a different business situation. They had a lot of business going on. Our position, and there's not specific evidence other than inferential evidence, Your Honors, but I believe that they made a business decision to let Allianz take the money and withhold it as they were paying the ongoing commissions that were due as a business decision. But even they didn't have an obligation to pay Allianz in this situation.
Doesn't that cut against or hurt you a bit on the argument that the claim accrued, all claims accrued in June of 2006? Because, I mean, if you're saying it was a business decision to let those funds, when did the loss occur? That's what I'm getting to. When did the loss occur such that they could actually bring suit?
June 23rd, 2006.
And why?
Because they were told in the letters that we are transferring the debt to you.
Okay. So let's say they filed that in Superior Court, and a week later you shoot off your motion to dismiss saying, failure to state a claim. This isn't even ripe. Where's the allegation that they've incurred
Because
any
it's not-
loss?
I'm
That
sorry,
they-
Your Honor, I
that
didn't mean to
they've
cut you
incurred
off.
any loss? I mean, wouldn't you have to have some basis to file suit saying, look, we've been damaged? And I guess the question is, how have they been damaged?
The INA versus Valley Forge case answers the question. There's different kinds of indemnity. They're saying, because it's the only argument they can make, that it's loss-based. But when you look at the cases where it's loss-based, it's because there's some contractual language that says so. Their claim essentially and really is an equitable indemnity claim, because the contract, the only contract he refers to that has this, quote, loss language is the agent agreement. And they cite the indemnity language from the agent agreement. Don't forget, that document is between Allianz and Collingwood. It says the agent will indemnify company, Allianz. It doesn't say agent will indemnify other agents. If they wanted it to say that, they would have said it. And that gets to Judge Thumma's point on the third-party beneficiary theory. Arizona's law specifically says they have to be identified, and the benefits of the contract have to specifically be intended for that third party. That's not the case here. All of these documents were intended, if anything, to give any benefit to the insurance company. And that's why the trial court properly noted that if there were these chargeback rights, they didn't flow as between North Star and Collingwood. They flowed between Collingwood or Ayala and Allianz. So to get back to your question, Your Honor, the reality is that this is not loss-based indemnity because there's not a contract that provides for it. These are liability-based claims. And when you get to the question of when did the liability attach, because under the Gus Rosenfeld case, the Supreme Court says statute begins to run when the right to sue happens. Those letters that Your Honor mentioned in your question to counsel earlier say, and I'll quote it once I can grab it. Refers to North Star, the first letter. Quote, I am writing you to follow up on our conversation regarding the amount we are, quote, transferring to you to recover outstanding debt owed. That's referring to Ayala and his $206,000. The second letter, also the same day, to North Star from Allianz, says the same thing with reference to Collingwood. Now, so the question is, what had happened that gives a right to sue here? The underlying lawsuit had happened. It had been settled. Allianz had paid the settlement, as had Ayala. Allianz had tried to recover from Ayala improperly, in my view. Ayala said no. Allianz had tried to recover improperly again, in my view, from Collingwood. He said no. They transferred the debt under the contractual relationship they had with North Star to North Star. They never sued North Star, but so there's not a lawsuit and a judgment that says you're liable, but it was in the facts of this case and on this record, that is the basis when liability attached. And that's what the trial court held. The trial court even went a little bit further than I argued in front of the trial court, to be frank, because he noticed that when Allianz settled, which was a little earlier in May of 2006, then the liability theoretically flowing up the chain attached then. So the court in his minute entry said it's May or at the latest June 23rd, 2006, and he was right. Nothing else had to happen to give North Star a right to sue. Everything else that happened thereafter was only Allianz's effort to collect on the debt it had transferred to North Star. Does that answer your question, Your Honor?
Thank you.
Okay. Now, with respect to the third-party beneficiary, I think I answered that question. If you have any questions, I'm happy to address that further. But in terms of the statute of limitations, we've talked about the accrual. We've talked about the letters. The Gus Rosenfeld case establishes when it begins to run. Now the question is, which statute applied?
So is it your position that statute of limitations takes out all claims? I mean,
All the remaining claims, yes.
Opposing counsel got, he listed 5 claims this morning. So it's your position that all 5 of those claims should be removed or are barred, are time barred.
Yeah. There's a few reasons for that. They first cite the Evans-Withycom case to try to suggest the proposition that their implied contractual indemnity claim would be saved or subject to the 6-year statute of limitations. And they cite Evans-Withycom for the proposition that an implied contractual indemnity claim would be subject to a written breach of contract position. When you read that case carefully, however, one, it doesn't even evaluate the statute of limitations. It's a statute of repose case. Second, in that case, the court in footnote 6 says we're not even going to make the decision here or decide whether implied contractual indemnity is subject to or would be something that would be subject to the statute of repose. And it certainly didn't go there to say that it's subject to the 6-year written statute for written contracts. So the court here has to get to the question, is there a written contract that gives a right to give a 6-year statute? The answer is no. There's not even a written contract from which an implied contractual indemnity claim can arise because it's between the other parties, as Judge Orozco pointed out. So then we get to where the trial court was. 3 years on unjust enrichment. 4 years for anything not covered. 1 year for a contribution claim, if it's statutory based. And on their contribution claim in this setting, Your Honors, they either have a Yukata claim, that's statutory, and that would be 1 year. They don't have a contractual claim for contribution because there's no contract that says so. And they don't have a claim for contribution anyway because it's barred under 877.6 of the California Code of Civil Procedure. So if you take the longest statute of limitations that applies, which is what the law would suggest the court should do, it's 4 years. This complaint was filed February 14, 2011. It accrued at the latest June 23, 2006. It's barred. Your Honor, the other issue with respect to the merits positions. First, on the indemnity arguments. The law is that if an indemnitor seeks indemnity, he can't be at fault. They say Collingwood is liable for indemnity effectively because he supposedly didn't properly supervise Mr. Ayala. They don't have any record of that. They assert it. But remember, both Collingwood and North Star are vicariously liable. If North Star didn't do it, or excuse me, if Collingwood didn't supervise, neither did North Star. And therefore, North Star can't seek indemnity on that basis. With respect to the unjust enrichment claim, first of all, there has to be an impoverishment, and it has to be unjust that somebody is withholding a benefit for the plaintiff. Besides the claim being barred by the statute of limitations, there's no rational reason why Collingwood should pay for monies that were paid to Ayala that he never received. If they wanted to sue somebody, they should have sued Ayala. That's where the money is. And secondly, it's not unjustified anyway. If you adopt or believe their arguments, they were equally liable with Collingwood under the joint and several provision that they've referred to. Assuming that's true, it's not unjustified because in this setting, they're liable, they paid, but that doesn't mean that Collingwood is liable. And on the merits, he's not subject to unjust enrichment. Unless Your Honors have another question, I would certainly just say, Your Honors, the trial court again was right. We would encourage the court to affirm, and we have asked for fees under 34101, 12-34101, and would ask the court for permission to file an application.
Thank
Any
you.
other questions?
I don't
Thank
believe so.
you.
Thank you. Rebuttal, Mr. Klopp.
Just a few quick points, Your Honors. Number one, heard Mr. Brooks again raise the issue of an oral contract. The oral contract between North Star and Mr. Collingwood didn't involve these issues. That was an additional oral contract superimposed over the AFMO addendum, whereby North Star said to Collingwood, you're going to be the AFMO. In addition to what Allianz pays you as AFMO, I'll give you some additional commissions out of what I get related to Ayala's sales. So it didn't have to do with the indemnity rights. It only shows the additional monies that Mr. Collingwood received with respect to Ayala that he now wants to wash his hands from. Number two, going to the statute of limitations issues. The INA insurance case says that the first step when we're determining liability or loss indemnification is look at the operative contracts. You will not find that in any of the indemnification provisions in any of the agent agreements or the AFMO addendum or any other contract the word liability. It refers to loss. Under INA insurance, that's a loss indemnification. With respect to an unjust enrichment claim, my client has to suffer an impoverishment before there's a claim. That's a loss. Liability, claimed liability, is not an impoverishment. With respect to, the AFMO addendum, again, there's a joint and several obligation. Collingwood signed that AFMO addendum, disputes it. That's a fact issue that was ignored. And North Star signed it. If they're both joint and several obligors under the same contract, it's difficult to imagine how they don't have rights vis-a-vis one another. And that's what the California Food Service case, which is cited in American Continental Insurance, recognizes as well, is that if you have co-indemnitors of the same loss.
Mr. Klopp, I'll need you to wrap up.
Oh, sorry. If you have co-indemnitors of the same loss, they have rights with respect to one another under a theory of contribution.
Thank you.
Thank you, Your Honors.
Counsel, thank you. Thank you for your briefs. Thank you for your oral presentation today. We will take the matter under advisement. We'll issue a written ruling in due course. We'll now take a brief recess while we set up the courtroom for our next case. Thank you.